सब लोग का हो गया, स्टार्टिंग के 2 मिनट ऐसे चलेंगे, गुड इवनिंग करते हुए। कौन सा क्वेश्चन? क्या क्वेश्चन बता तो?
In the
Yes,
various security forces affecting the
kindly,
human population
kindly,
environment.
Shivani Singh, Shivani Singh, kindly mute your system, please. All of you, I request all of you to kindly mute your system. I don't want to mute all of you because in between we can have the interaction. So that is the reason I don't want to mute. So better you keep maintain the discipline so that we will be able to discuss. So once again, I welcome all of you to this class, and today I'll be dealing with your business law. And this is business law is one of the important aspects in business. So you must be some laws you may not be aware of it, but if you know, then it will be helpful for your day-to-day life also. Not only for this academic purpose, it will be helpful for the for your day-to-day life, like law of contract, which is very important. Day-to-day life, many of you are doing contract, but you do not know what exactly contract is. So we'll be dealing with the contract law, contract, company law. Then we'll be dealing with negotiable instruments. We'll be dealing with Factories Act. We'll be dealing all these. These are the very important, not only for academic purpose, in day-to-day life also. It will be very helpful for you. Are you ready for the class?
Yes, sir.
Yes, sir.
Yes, sir.
Yes, sir.
Yes, sir.
Yes, sir.
Yes,
Okay.
sir.
Okay. Let me upload my PPT now. Are you able to see PPT?
Yes, sir. It's visible.
Yeah.
Yes, sir.
Yes, sir.
Yes, sir.
Yeah. You can see the business law. The first unit is your law of contract. What we are going to do discuss in this one: law of contract. What is agreement? What is offer? What is acceptance? What is consideration? Who is capacity? Who has the capacity to make a contract? What is contingent contract? Quasi contract? Performance, discharge, remedy of breach of contract. These are the things we are going to discuss. Now, first of all, we should know that what exactly business law is. Why we are going to study business law? You know, business law also referred to as mercantile law. Many of the commerce students, they must have studied mercantile law. It is also called as mercantile law. Comprises a set of laws connecting the business world, trade, commerce, and industry. Related to business, trade, commerce, and industry, this law is framed, that is called as business law. Generally, it includes the law pertaining to the contracts, sales of goods, partnership, companies, negotiable instruments, insurance, consumer protection, payment of bonus, payment of gratuity, minimum wages, carriage of goods, insolvency, etc. And with the first development of globalization, the scope of business law is also widening. You know that now your business is globalized. It is not now it's called as all the countries altogether it's called as global village. It's like a village. So your multinational, many of the multinational company, they are doing business. So the importance of law is very uh, you can say it is very important to maintain the law. Different countries have different kinds of law. So once you are aware of the law, then it will be easier for you to deal with the business. So to meet the felt need of the provision of uniform law to regulate the contract between entered into among the parties involved, the business transaction, the Indian Contract Act 1872 was enacted. Why this Contract Act was enacted? Because nobody should take the advantage. To meet the felt need or to make a provision, uniform law for all, so that uniformly everybody will be dealt. That is the reason 1870 Contract Act 1872 was enacted. Thereafter, various other acts also have been enacted. Now we can see that what is the sources of business law, from where this law has come. Just basic introduction I am giving so that you will be able to understand. The sources of business law is English mercantile law, mainly from the British law. In English mercantile law, it has been derived. The statute law, the statute which you are being enacted in our parliament, those are made as a law and it is enacted. Then case laws or judicial decision, like some case laws, some case has taken place, some decision has taken place by court, some judgment has given by the court. Those can be also included in the, from that also business law has come. Similarly, judicial decision, for example, Supreme Court has given decision for the particular case, that can be enacted in future, that can be enacted if it is felt necessary, that can be enacted as a law. So these are the various sources of law. Then custom and usage. What are the custom in the society and usage in the society, based on that law is formed. So these are the common sources of business law. Now our main topic is law of contract, which is Indian Contract Act 1872. If I ask all of you that have you done any contract with anyone?
Yes, sir.
Any example? Can you give one example?
The contract was with the company for project to start. Yeah, and then binding it was with how many years I'll be associated with the company and what will be my offerings and services.
Okay. Anyone else?
So agreement between the builders and the purchasers.
Okay. Any one of you who has not done any contract till now? You are around 157 or some students. I am asking all of you who has not done any contract.
I have not done any contract, sir.
You have not done any contract?
Study what's contract.
Are you
Me
sure?
also, sir.
Sir, can you say what is contract? Then I will say.
Sorry?
Marriage is also a contract, sir.
Yes. Anything else? Who said he has not done any?
Having employees in terms of contract is also applicable, so when it comes to organizations. There is
No, who says she has not done any contract? Have you, do you have any cell phone number with you?
Yes, sir.
You are having cell phone, isn't it?
Yes, sir.
Yes, sir.
You have taken the number, you have signed somewhere, isn't it? See,
While we are downloading any app, we have
Find in the terms and
you have
condition.
bank account, you have signed that, yes, I agree with that.
That's
That is
right.
also a contract, isn't it? So knowingly, unknowingly, you are doing many contracts because
Yes,
you
sir.
are not aware what exactly contract is. For example, if you are traveling by a bus, you are buying a ticket and getting inside the bus and getting down at your destination. Nobody asks you anything. And you just went straight to bus and you have purchased the ticket. That is also a contract. That is called implied contract. Okay. We'll discuss later on what exactly is. But all of you have done contract some or other way. But we are not aware of it. They ask the bank people, they ask us, you have signed here, here, here. The statement you have never read. So it is a long statement. So agreement, what you are agreeing with those terms and conditions, you do not know. So ignorantly, you are just signing. That means you have made a contract. They must have many terms and conditions in that, which may not be, you may not be aware of it. The law relating to Contract India is contained in the Indian Contract Act 1872. In this Contract Act 1872, all the law related to contract is mentioned. The Act is mainly based on the English common law and came into force on 1st day of September 1872. So it is based on the English common law and came into force on first day of September 1870. That's why it is called as Contract Act 1872. It extends to whole of India. The Act deals with the general rules relating to the all types of contract, section 1 to 75. You no need to remember all the sections, but for your information, the section 1 to 75 it deals with contract and contains special provision governing specific contracts such as those bailment, pledge, indemnity, guarantee, and agency. These are the things it is not included in your syllabus. This bailment, pledge, indemnity, guarantee. This is advanced contract or contract 2. It has not been included in your syllabus. Otherwise, it would have been too vast. So this act also contained provision relating to contract of sales, goods, and partnership. In contract, sales of goods and partnership also included. Besides, there are separate acts that deals exclusively contract related to negotiable instrument. Any idea about negotiable instrument? Anyone?
Bank.
No, sir.
Banks.
Transferable, sir.
What is that? Who said bank?
Sir, the law
Myself,
related
sir.
to checks and bill of exchanges, sir.
Yeah, check also. It is a negotiable instrument.
Bill of exchange, sir.
Yeah. Bill of exchange, promissory note, these are the negotiable instruments. So it is important to note that Contract Act does not cover in the ambit any social custom and usage or trade. Say if there is any social custom, usage or trade, so those are not included in this one. So that will be having that separate rules and regulation. Now let us see. The relating to contract in India is contained in the this we have gone through. Now the next slide. The contract defined. In section 2H, it has been defined what is contract. So an agreement enforceable by law is a contract. Here you can see, you can observe it clearly that agreement, there are two parts. One is agreement. An agreement which is enforceable by law is a contract. The definition is an agreement which is enforceable by law is a contract. Therefore, a contract has two components. One is agreement and another one is obligation which is enforceable by law. Now you can see contract equal to agreement plus legal obligation. Now, what is an agreement? An agreement is the outcome of the consensus between the parties who enter into a contract. It is the consensus between two parties or the parties who are entering into the contract. That is, the promise made between them represent concurrence on their mind. So what the promise is being made, and both minds are similar way they are accepting it. That is an agreement. This would not be an agreement if the parties do agree but not in the same thing and same sense. If both the parties are agreeing to the agreement, both the parties they are accepting the agreement but not on the same thing or same sense, then it cannot be called a valid agreement. It has to be for same thing on same mind. For example, you want to sell a car for 50,000 rupees. The person B, he has accepted, yes, I want to buy your car for 50,000 rupees. But he doesn't know which car you are going to sell. You have two cars. Honda car you have, Maruti also you have. Which car you have not mentioned, which car you are going to sell to him. So that person may be in assumption that you will be selling Honda car for 50,000 rupees. He doesn't know you are going to give Maruti car. So in this case, the mind is not matching. So if you say, I am going to sell my Maruti car for 50,000 rupees, he said that, yes, I am ready to pay 50,000 for the Maruti car. That means this is the agreement. It is accepted by the parties. If it is not clear which car he is going to buy, then it is not a valid agreement. Is it clear?
Yes, sir.
there has to be consensus ad idem. In legal term, it is called as consensus ad idem. That means you have to think in similar mind. For same thing, same sense, you have to accept it. Section 2C of the Indian Contract defines the term agreement as every promise or every set of promises forming consideration for each other is called an agreement. What is that? Every promise. If you make a promise or set of promise, both of you made a promise. You want to sell the car, Maruti car. He also ready to pay 50,000 for the Maruti car. Forming consideration. What is the consideration? For the car, you are paying 50,000 rupee. Consideration for each other, you are paying 50,000 to him. He is giving the car to you. So this is called as agreement. Every promise or every set of promise forming a consideration for each other is called an agreement. Here you can see the example. A received 10,000 from B and promised to supply him 10 bags of rice after 10 days. It is a promise. It shall be a set of promise if A promises to supply 10 bags of rice after 10 days and B promises to pay him rupees 10,000 after the rice is supplied. Thus, agreement, what is that? Offer plus acceptance. If you give some offer to someone and other person he accepts it, then it becomes a promise. It becomes a set of promise because you have promised to supply, he has promised to pay. So this is called an agreement is equal to offer plus acceptance. What is a contract? Contract is agreement plus legal obligation or agreement which is enforceable by law is contract. Here the agreement is offer plus acceptance. There has to be an offer and which is to be accepted by other party. Is it clear what is agreement?
Yes, sir.
Yes, sir.
Now, what is the promise? Then what is the, we'll go one by one. Then what is a promise now? The term promise defined it to be. 2C, what it defines? First one is section 2S defined what is in contract. Then section 2C, of course you need not to remember all these sections. If you write definition, it will be all right. Section 2C, it calls as agreement. What is an agreement? Then section 2B says about what is a proposal or offer. A proposal, when accepted, becomes a promise. When you made a proposal to your friend or someone else, when he accepts it, it becomes a promise. Then what is promise then? Thus a promise implies an accepted offer. The offer which is accepted is called a promise. Then we need to see next step is what is an offer then? Offer means proposal. Again, section 2A, what it says, when one person signifies another his willingness, when he expresses his willingness to do or not to do something with a view of obtaining assent of the other to such act or abstinence, he is said to make a proposal. When a person makes a proposal or offer to another person and expresses what is the signifies another his willingness to do something or not to do thing with a view to getting his assent is called as proposal. Then what is acceptance? Acceptance has been defined as section 2B as when the person to whom the proposal is made signifies his assent, he says that yes, I am accepting, then it is called as acceptance. And a proposal when accepted, it becomes a promise. Here I have given one example. You can see A lost his cell phone and announced that anybody who brought his cell phone back home would receive rupees 500 as reward. We heard this thing. We heard the announcement and brought the cell phone back home. He is said to have accepted the proposal by doing the act required by A, and hence he can recover the reward. Any doubt?
No, sir.
No.
Yeah. What is a contract? It is clear. Then what is an agreement? Then what is a promise? What is the proposal? What is the offer? Then we need to go promiser and promisee. Who is called as promiser? A person who makes a promise is called a promiser or offerer or proposer, anything you can say. And the person to whom the proposal is made is called as promisee, offeree, or proposer. Okay. In case an agreement is set of promises, then a person becomes a promiser and promisee. So set up agreement, like he wanted to make 10 kilo of sugar for 10,000 rupee. He has to give after 10 days, and another person, he has also accepted that one, that once you I get the sugar or rice, then I will pay 1,000 rupee to you. So this is a set of promise. So he is a proposer and he is the promiser, he is the promisee also. Thus, if there is an offer, acceptance and consensus item between the party, if there is an offer, if somebody puts an offer and another party he accepts it, and both the parties have consensus item, both the parties are accepting for the same thing and same mind, then there is an agreement. However, this agreement does not become a contract unless there is a corresponding obligation that is enforceable at law. Both the party, they should have some obligation, like he wanted to sell his car, and other party he wanted to he will pay the price. So both the parties, they are fulfilling their obligation, and this is enforceable by law. Selling a car and buying a car is not against the law, it is enforceable law. If he violates the declined to, if you are paying 10,000 1 lakh rupee and he is declined to give car, an agreement is made and he is not ready to that, then you can go to the court of law because it is enforceable by law. For example, there is an agreement between two parties. So party A says to party, put a proposal to party B. If you kill C, I'll give you 1 lakh rupee. Whether it is a valid agreement or not.
No, sir.
Why it is not?
Sir, it is criminal act which is not supported by law.
Yeah, it is not enforceable by law. So this kind of contract, even though it is a contract, although we are fulfilling, but it is not enforceable by law. There is a proposal, there is an acceptance, there is a obligation, everything is there, but it is not accepted by law. Thus, it will not be a valid contract. So, however, this agreement does not become a contract unless there is an agreement enforceable by law is a contract. But here, the agreement is there, which is not enforceable by law. It is not a contract.
There should be a lawful object.
Yeah,
Lawful object.
there should be lawful object, which will be accepted by the law. Now, we discussed that there should be legal obligation. What is a legal obligation? Again, it is defined in section 10. The obligation is called it is the legal duty of a person to carry out what he has promised to do or not to do. Suppose we have made an agreement that I want to sell my Maruti car for 1 lakh rupee, and the person B, he has accepted that I will pay 1 lakh rupee when you deliver the car to me. If any of the party violates from their agreement, then both the parties have all the responsibility. It is the legal duty for both the party to fulfill the requirement as per the promise they made. So it is the legal duty of a person to carry out what he has promised to do or not to do, whether it is a written agreement or oral agreement. Sometimes there is agreement, it has to be done in written, like land transfer of property, etc. And sometimes oral promise also it is accepted. Oral agreement is also accepted. So whatever the person, both the party have accepted, it is their legal duty to fulfill that. If somebody does not follow that, the other party has all the right to go to the court of law. All agreements are contract if they are made by the free consent of the parties. If parties are competent to enter into a contract, if there is a lawful consideration and there is a lawful object and not hereby expressly declared to be void. If these are the conditions are fulfilled, then there can be a contract. All agreements are contract if they are made by the free consent. If you show a gun to a person B and it says that if you don't buy, I will kill you. So forcibly, if you have taken the made the contract, that is not a valid contract. There has to be free consent. He should be, the other party should be freely, he should accept that one, and the person who is accepting, he should have given his action of free consent. Then only it will be a valid contract. Otherwise, it will not be. The party must be competent to enter contract. Like if it's a minor, if you're doing a contract with a minor, it is will it be valid?
No, sir.
Yeah, parties.
No, sir.
We'll see who is competent to contract. We'll discuss. So party should be, the another condition is party should be competent to enter into a contract. The another object is lawful consideration. There should be lawful consideration. It should not be unlawful. Like smuggling goods, bribe, all these things, it's unlawful. So there should be lawful consideration. And with a lawful object should be lawful and not hereby expressed declared to be void. If something is declared void by the government, that should not be, that cannot be a contract.
It should not be against public policy also, no, sir? It should not be against public policy.
Yeah.
Like, yeah.
So these are the things you have to follow. Therefore, a person becomes legally bound to do what he has promised to do only. So you are legally bound. What agreement we have done, what you have promised. Suppose you have made a contract with the company. What they have given in the agreement, the company has all the way to, they have to follow that one. The employee, if it is being cheated to the employee has got all the right to go to the court of law to take the center. Okay. So therefore, you should, as in most of you are working in some corporate sector. You might have signed many of the contract. So you should know that what exactly contract is, what is the valid contract, what is the void contract, what is legal contract. You should know that whether you have taken some consent, forcibly some consent, or those things will not be accepted. So therefore, a person becomes legally bound to do what he has promised to do only if the following conditions are fit. What are those conditions? Capacity of the parties. The parties should be capacity to contract. Only those persons who are competent to contract into a contract can create a valid obligation. Otherwise, no. We'll see who are competent to contract. Free consent. Absence of consent does not create a legal obligation. If you don't have free consent with some threat or something, it is being done, then it will not be a legal obligation and contract will not be, it will be a void contract. Lawful consideration or object. Consideration means something in return. Like you wanted to sell a car, the other party will pay you money. For example, quid pro quo. It is a legal term which is called as quid pro. It is a legal maxim. For example, A promised to give his bike to B for no money. Here there is no consideration, hence no obligation. A wanted to promise to give his, I will give you bike without any money. Here there is no consideration. B has not given anything to you, hence there is no obligation. If A doesn't give the bike to B, B cannot go to the court of law that he has promised, but he has not given bike to me. You cannot say this is a contract or valid agreement because there is no consideration for both the party. Is it clear?
Yes, sir.
Yes.
Yes, sir.
I'll ask you one question.
Yes, sir.
I'll ask you one question here. For example, a father made a promise to his son that in annual examination, if you score 90%, I will give you bike. The son has scored 90% in the annual exam, but father, he has not given bike to his son. Can the son go to the court of law?
No, sir.
Why?
No, sir.
Why?
No.
Because first of all, the
No
son is
obligation.
minor.
No, he's a major.
And-
He's a major.
It is not written contract, sir.
Sir, there is no agreement now.
And there's no
Not
any.
legal.
obligations from.
Because it is a void contract.
No obligation.
It's not a valid obligation.
Justification. Now
No
you
consideration.
know that what is agreement, what is promise, what is who is proposer, who are property, what is contract. Everything is known to you. Now this is a case given to you that father has made a son has made a proposal to, he has put a proposal to his father. Father has accepted. When it is accepted, it becomes valid agreement. And he promised that he will, once he score 90%, he will give the car. And the son has scored his obligation he has done. Now father has to fulfill his obligation, but he is not fulfilling his obligation. Then what is the remedy here? Can the son go to the court of law? If yes, then give justification. If no, then why?
So there is not any written agreement between father and son.
Not necessary. Even oral agreement can be accepted.
Sir,
He
there
should not
is
go
no
except he
lawful
has
offer
contract.
and acceptance.
Sorry?
No evidence.
Yeah, okay, I'll give you evidence. Somebody give witness. Then, in that case, my meaning is whether it will be a valid contract or not. It will be considered, a court will consider or not.
Sir,
Court
it
will
is
consider,
a
sir.
valid contract if his son is not minor. If it is he is a minor, then it is not a valid contract.
The son is not a minor.
There is no consideration.
No, here one thing is using, there is no intention to create legal obligation. In love and affection, if there is something, a statement is being given, you cannot go to the court of law. There is no intention that if I don't give the car, son will go to the court of law. And son has never thought that if my father give me car, I will go to the court of. There is no intention, consensus of mind that if you will not give me car, I will go to the court of law. So there is no consensus of mind. There is no intention to create legal obligation. So there it will not be a valid contract. In that case, son cannot go to the court of law to recover his bike. Is it clear? There is no legal intention to create legal. Now we'll be studying. Legal obligation. What is that? A promised to pay a sum of money to B. B smuggles the object proposed by A. In this case, there is no lawful object. Here also it will be, there is no legal obligation because it is for the unlawful object. Intention to create legal relationship. Social obligation can't bring legal relationship. Here, father and son, they have social obligation. For example, father promised his son to pay rupees 100 per day for pocket expenses. However, later on did not pay the said amount. Therefore, if the parties do not intend to be bound by the law at the time they make promise, nothing can bind them to their promise later on. Initially, they never thought that if I will not pay 100 rupee per day, the son will go to the court of law. And son also never thought that one. So by the time when they create a promise, by the time there was no intention. So later on it cannot be called as the legal obligation of his father to pay. Possibly,
But sir, this is not ethically right, no?
which one?
This thing, if someone has made a promise, let it be like a father or son, but if it's like it's anything, a relationship is coming between, but then if it's like any kind of any promises are made, it has to be ethically followed till the end, and the person has a right actually to go to the court and file a case against this.
What is the
Why
definition?
will this not be considered?
Because there is no intention to create legal obligation. There is no consensus ad idem. What we say that when you are making a promise, it should be both the parties should think about the same purpose, same thing, and same intention. There was no intention that son will go to the court of law. By the social obligation, he has said to his son. So that cannot be considered as a valid obligation. Okay, if initially, for example, he has given the written agreement and he has accepted that one. If I don't give you, then you can go to the court of law. Then both the parties are aware that if I will not give him the car or give him the bike or 100 rupee per day, he will go to the court. In that case, it can be. But here there was no intention. If intention is there, it can be. Let it be father and son. Is it clear?
Okay, so basically it means that there has to be a statement saying that if I don't do this, then you can furtherly go and file a
Yeah,
case
that
against
means
me.
you have the intention. You can go
Yeah.
against me. There is an intention. But if you say, was there any intention? When father say, I will give you 100 rupee per day pocket money, later on he didn't pay. Was there intention that if I don't pay, then she will go to court of law? She will recover payment. It is not like that.
Sir, then why father said casually to son? It is a
Yeah.
fake promise, right? When there is
There
no
should be a case
intention
of fraud
to,
on him.
yeah, then there is no intention for a father to give either bike or money. Then why he is promising to his son?
Just a second, please.
Sure, sir.
Yeah, tell me.
Sir, I'm
See,
saying,
there is no intention. The law says that, definition says that there has to be intention to create legal obligation. There is no intention.
sir,
If-
what
Excuse me,
is
But
sir.
sir, all these examples only lead to a kid one day that he will keep ignoring these kind of efforts. For example, some brand promised a customer to give him a gold coin on the purchase of something. He
Yes.
has won. But now the thing is that if the kid has that same kind of a habit where he keeps on ignoring these kind of things, he
There
will
it is
always
different.
not be a
Here
good
it
citizen
is-
of India.
There it is different. Here there is no, in case of company, there is no social obligation like father and son relationship. Here it is, there it is the intention. They have given advertisement, they have to pay. That is compulsory.
But sir, here father has made a fake promise to the son, for which son had spent his whole 6 months
It
or
is
1
not
year
a
in
fake
studying
promise.
hard.
It is not a fake promise. It is the motivation to his son. It is not, he doesn't have any intention to create legal obligation.
Sir, but if the father promises his son that his assets will be given after a few particular years, no, then he can move, right?
No, in
If
that
it is
case,
regarding to the assets.
you make an agreement, you register, make a register paper or something like that. In that case, you can go. But here there
Regarding the
was,
asset, yeah.
yeah, here there was no intention. If you would have intention, then he would have make an agreement paper and he could have registered it. He could have given that one. So in that case, son could have gone to. But there was no obligation, no intention to create legal relationship.
Sir, in
But sir,
this
there
case,
has to be, the kid has to go to the case. No, if in case, for example, we as a being a student right now, we have been promised from our childhood that you keep studying, then you don't have to study after 10, then study till 12, then you don't study, then you'll be relaxed. Then you study till graduation, then masters, then do a job, then you'll be relaxed. So life was always making a fool. So now if we don't stand for our rights and these things, these fake promises will be kept on happening in our life. So one day that kid has to always stand. There has to be a law for this.
See, there again, you cannot create a law for the, if you are shouting to your son for his motivation or something like that. You cannot say that you are going against the law. Why you are shouting them? You don't have right to ask him or right to beat him. So father is doing something for the benefit of his child. It is not.
But legally, son also can't beat to her kid as well. It's against, it's a harassment policy now.
Then there is.
And now if a kid goes and files a case against his father or a mother or a parent, now parents will go under the jail, behind the jails.
That is to be considered in the court of law, that whether it is intentionally to create harm to the son, even they can go. Even somebody, third party can go to the court. In some of the countries, if you are not taking care of your child, the government will adopt the child. It is there, law is there. But here, you cannot say that this is for legal purpose. He wanted to make his career better. He wanted to do something. He doesn't have anything to go against the child. So in that case, law states that if you have legal intention, then see, in case of if you study the law, there's a law of torts. In that case, They will see the what is your mind, consensus of mind. When you have killed someone, suppose you have fired a bullet without any intention, lawfully, but somebody was behind the bush and he has been killed. Then here court will, he will be punished for some reason, but it is not that his intention to kill the person. So intention will be, consensus of mind will be seen. So here in contract also, if there is a social love and affection, in that case you cannot say that he has the legal obligation or his intention to create legal obligation. In that case, it will not be accepted. Like with a child, if third party, the guardian, he makes the contract, he can make on behalf of the guardian. But you are dealing with the directly with the child, then it will not be, child will not be responsible for any case of loss or any obligation. He doesn't have any obligation because he doesn't have right to contract. Anyway, we'll discuss, otherwise it will take long time.
So that's when without any legal obligation, there is no agreement.
Yeah, it cannot be. It is not a valid agreement or valid contract cannot be.
Sir, here the father intention is just to motivate the son. That's
Yes,
it.
yes, of course. Not to create.
And so verbal contracts are not valid?
Yeah, it is valid.
Yeah, obviously.
It is valid. Sometimes it is valid, but here in this case, here social, his father, if somebody else could have done, in that case it may be. But in this case, because father and son, they have some social obligation. So what here intention to create social obligation cannot bring legal relationship. Okay.
Okay, sir. What if son mentioned that if he didn't get the bike, he will go to trial?
Right. If he would have mentioned and father would have accepted, then it could have been. If there is an intention that if you don't pay me 100 rupees, I will go to the court of law. Father says that yes, okay, you can go. Then in that case, it could have been because there was an intention. Okay.
And sir, if son here goes and does a suicide because of his the heartbreak, because dad did not fulfill his promise, will dad be punished for that?
I didn't get you. Once again.
So here, if after knowing that father is not giving a bike, son goes and does a suicide, and after this, will father get punished because of it?
Okay.
No.
Yeah, he can be punished for not for the suicide completely because he didn't take care of his son or for some other reason he can be made guilty. But in this case, he has not paid 100 rupees and with emotion, the son has been, he has taken his life. So he cannot be the sole responsible for that one.
We see many cases like that, like small children are refused to
Later on, he will
play
be released on
mobile.
bail. Later on, they will relieve him because he was not having the intention to kill his son.
Yes, that's it.
But the son, keeping hopes higher, right? When the father promised, for that he do like he keep extra efforts to get the result.
Yes,
At the end
that
of the
is
day,
true.
yeah,
That
sir.
is true. But what you said that the term is called a consensus ad idem. Both the party will have same intention. Father should think that son should think that I will go for the taking action. Father should have taken that yes, if I don't do that, she will take action. If this is the intention, then definitely father will be held responsible.
Okay, sir. Okay, sir.
Okay, we'll proceed further. Next one is possibility of performance. So, for example, A promise. Here you can, another case you can say, A promise B that he would make the sun rises in the west. If B pays him rupees 1 lakh. If you pay 1 lakh, B pays 1 lakh, he will make the sun to rise.
Excuse me, sir. I am wondering, so much of support for the son side. I am really wondering where the society is going. Why so much argument for the? He's saying that.
No.
I'm really wondering, sir. I don't know what is happening in the society, sir. So far, he has only grown up, sir. That boy, he has sacrificed many things, in his life. Son, our father has sacrificed many things for his son.
Yes.
There may be some delay in fulfilling his needs, sir. He will not fail. Father never fails.
No. Here the point is not to get an emotional because it's a father and son's relationship. Here
That
we
is
are
what,
talking about a
sir.
business is because
I have
one
not
day
heard
this son
any.
will be also just did the same promise, fake
Sir,
promises from their
that's true. That's
bosses,
true.
from their companies, and because this was not brought into a practice anytime in childhood itself, he will
What sir
always
is
be
trying to
accepting
tell
it
you,
and
yeah. But this is not practical in our India. So I'm from legal side for your information. So far we have not heard any case such like sir is quoting. So far, I don't know in future if this may turn on the other side. So I don't know. But legal obligation, he's saying legal obligation because of the absence of legal obligation, there may not be any valid contract. He's saying, sir is saying, he's justifying that only, sir. So with that, I think we have to leave. Thank you, sir. Thank you for the opportunity. Thank you for
but
the
I think
opportunity.
legally we should get responsible because
Yeah, that's
this is
true,
not
but
never
not. You
taught
should
to
not
us.
think too much of because the father has sacrificed whole life for the sake of the
No,
son.
no, that's what I'm
Uh,
saying, sir. Don't get
Sir, he
emotional
may
because it's
fulfill.
a
No.
father. I'm
Take
just
for
telling you, it has to
example,
be brought into a practice from childhood.
that's true. That's true.
Even
At
if your
one point
school
of time,
teacher
he is
or your
going to
school
fulfill.
driver,
No. At one point of time, he is going to fulfill his needs, sir. Definitely. It is not
Yes,
going to
sir.
be the long run. He is saying one example for him. That's it. Okay. Sorry, sir. Thank
Not
you.
only not
Yes,
only
sir.
the bike, he can give later on. He can give the reward him with a car also. He can be, but he wanted. It is not. If he is not giving, it doesn't mean that. If intention is there, it can be. But some of the countries there are the rules. So in our country, this is the rule we have to follow.
Sir, everything is fair between love and war, sir. Don't worry.
Yeah. So we'll go further. Because it is contract is very interesting. So next is possibility of performance. A promised to B that he would make the sun rises in the west if B pays him 1 lakh rupees. It is not possible to make the sun rise in the west. So, and B agreed to it. This agreement does not create any legal obligation or it would not be enforceable by law. Here A promises, B accept also, but it is not be possible. So it is not, even though they have proposal, acceptance, agreement, everything, but this will not be valid. You cannot go to the court of law against each other because it is not enforceable by law, because it is impossible to perform. Next is meaning should be certain. Example, A agrees to say B is horse. There is nothing whatever to show which horse is intended. He might be having black horse, white horse, gray horse, but he has not mentioned which horse he is going to sell. So the agreement is void for uncertainty. There is no certainty which horse he is going to sell. So he should maintain that I will sell this particular, like I told you about the car. I wanted to sell the Maruti car, not Honda. That should be clear. Certainty has to be there. Then again, see legal formalities. An agreement to make a gift or for natural love and affection should not only be in writing but registered also. So here you can register. Like father could have been registered in a piece of paper, or son could have been taken it. In that case, he could have made responsible. Here, an agreement to make a gift or natural love and affection should not only be in writing but registered also. It should be registered. In the absence of any such specific requirement, an oral agreement it is as enforceable as a written agreement. So it will be agreement will be accepted if it is so. If it is legal formalities there, you have to write and register also. Agreement not declared void. Indian Contract Act has specifically declared some agreement to be not enforceable by law. For example, agreement in restraint of trade, agreement in restraint of marriage, wagering agreement, etc. Thus, the law contract is not the whole law of agreement. It is the law of those agreements which create obligation. There has to be some obligation, legal obligation. Then only it will be called as like wagering, like lotteries. Some lotteries are banned. So in that case, you cannot say that it's a valid agreement. I hope it is clear now.
Yes, sir, clear.
Now we proceed
Yes,
further.
sir.
Now you see the contract, agreement, promise and offer. A contract essentially is an agreement. The basic component is it should be an agreement. which is enforceable by law. An agreement is a set of two promises, one flowing from offerer and the other from the acceptor. A promise is an accepted offer. So when it is offered, promised by some agreement, some offer is given, other one is accepting, it becomes a promise. An offer or proposal is a promise of performance, which is, however, conditional upon a written promise or an act for wherein receives exchange for it. Like obligation, both the parties should fulfill obligation. For example, offer or proposal, then it will be acceptance has to be there, then it becomes promise, promise become agreement, agreement becomes contract. Now we see who is competent to contract. Competence to contract is one of the essential element of enforceability of an agreement. The following persons are incapable of entering into a contract. It can be two-way questions. Who is competent to contract or who is incompetent to contract? So these are the person are incapable of entering. Who are person who has not attained the age of majority. If the person is minor, so he is not competent to contract. A person who is not of sound mind, that is a person of unsound mind, is not competent to contract. A person who is disqualified by any other law to which he is subject and disqualified, he is not competent to contract. Now, what are the rules relating to an agreement with a minor? Agreement is void ab initio. If you are making any agreement with a minor, it will be void. Minor can be a promisee. Minor can be a promisee. Minor can be a promisee, but he will not be held responsible for his promise. A minor's agreement cannot be ratified. Later on, if he becomes major, you cannot ratify the agreement. Yes, when he was a minor, he had made the contract, and now he became the major, and this will be applicable to him. It will not be. You cannot ratify later on. No compensation is payable by a minor. You cannot get any compensation. If you have done any agreement with the minor, and if there is a loss, you cannot get compensation from the minor. The rule of estoppel does not apply to a minor. No recovering back the money paid. A minor can be sued in tort. In tort, that is a different thing. Again, if you study law, the law of tort is one subject. You have to study that one in detail. In that, again, same I was talking about the conscience of mind, all those things will be there. Then agency, negotiable instrument, partnership, insolvency, guardianship, minor's parent. These are the these will not discuss. Agency will later will discuss. Minor can be sued in tort. In case of tort, he can be sued, but in case of contract, it is not. So,
Sir, role of estoppel?
Law of estoppel means it will not be, suppose if he has not done anything or not able to fulfill his obligation, in that case, it will not be applied to that individual. So all this, it will be responsible to all the person who is making contract. So we'll detail with example. I will later on. I will explain you in detail. Yes.
So what is the meaning of first line agreement is ab initio?
Agreement is void ab initio. Ab initio in the sense beginning itself, when you are making an agreement, that itself is a void. It is not valid. So later on, whatever you do, it will be invalid only. It will be a void until unless you rectify the issue. So since the beginning, it is invalid.
Sir, is this slide available in the website, sir?
Slide.
Sir, it is available, but it was merged with environmental science, business environment.
Yeah, earlier it will be there. It is my slides only. It will be there in business. Earlier, business, environment, and law was one paper. Now it has become business, environment, another paper.
Can you share it, sir?
Yeah, I will share at the end. Not today. Once classes are over, I will share with you, so you can make use of it. Okay.
Okay, sir.
Okay, sir.
Yes, sir. Thank you, sir.
I think for today it is enough. We'll discuss next week. We'll be discussing about different types of contract. Okay.
Okay, sir.
Until now, anything you want to, now you can discuss anything.
Thank you, sir. Thank you.
Thank you very much, sir.
Thank
Thank you,
you,
sir.
all of you. But it is
Thank you, sir.
for many of you, yeah, many of you, it will be a new subject,
Yeah, sir.
Thank
Yeah,
you,
sir.
sir.
and many of you might have
Thank you, sir.
already studied law, contract, and commerce and all.
Thank you, sir.
Sir, to understand this subject, do you refer any website or like article to get deeper knowledge?
What is that? What is that? I didn't get you.
I mean, to understand this subject, like you refer any article or website or book?
Yeah, in general, we don't do, but if you are interested, I will refer you.
Yeah, sir.
Definitely, we'll do something and
Sir,
you can
BAR
see.
Act, Indian Contract Act, BAR Act is there, sir. You can go through that. It will be very clear.
Barrett is there. Yes, yes, you can buy the
Yeah,
Barrett
BAR Act
also.
available, sir. Yeah, yeah.
Yeah, it will be hardly 25-30 rupees. Small book will be there. So it will
Sir,
be a
sir, can you repeat it, please?
Barrett. Barrett. You can go to the any law seller, bookseller. Hardly 25-30 rupee it will be cost.
Barrett.
Barrett. Yeah. Or any of your friend advocate will be there. You can ask them. They will provide you. Otherwise, in the website also, website it is there.
Okay, sir. Thank you.
Okay.
Inquest
Yes,
is
sir. Thank you
connected.
so much.
It is BAR Act, sir. BARE, BAR
Yes.
Act. It is available in Sitaraman and Co. Sitaraman and Co. Either Mailapur branch or Paris branch. Tambuchetti Street, it is available. BAR Act. Small book will be there. You can easily understand by reading that.
Yes. Yes.
For the sake of our sir, I'm just referring it. Sir. Thank you.
Yeah, for betterment, you can have the, because you will be having
Thank
the
you.
latest act in that one. So you will be clarified all those things. Okay.
Thank you, sir. Thank you, sir. Thanks, sir.
See you next
Yeah,
week.
sir.
Thank you, sir.
Thank you, sir.
Thank you. Thanks a lot.
Thank you very much.
Thank you.
Thank you, sir.
Thank you, sir.
Thank you, sir.